All right. It is Friday, October 24, 2025. Welcome to Borderlines Canadian Immigration Law Podcast, joined as mostly always by Deanna. We occasionally record single episodes with our own guests. But we are joined today by Greg Chubak. And this has been an episode a while in the making. I'm very excited for it. Greg had a career with, I guess, then Citizenship and Immigration Canada, now IRCC, spanning decades. He's a former immigration program manager at numerous visa posts, including Vienna, Seattle, Seoul, Hong Kong, and Singapore. I told a few lawyers who've been practicing for a while that we were having Greg on, and everyone goes, "Oh, I remember that name. I remember that name." And sure enough, when we first connected, I searched your name in my emails, and I had a lengthy email from you explaining why one of my clients was inadmissible. We also pieced together in planning this that you may have written a decision that I unsuccessfully judicial reviewed. And coincidentally, I'm having lunch with a lawyer from the Department of Justice who is on that file in about 90 odd minutes. And he's good. He listens. And so we were just reminiscing about the case. So Greg, it's a pleasure to have you on.
Yeah, welcome.
Thank you. Nice to meet you, Deanna, and it's good to see you, Stephen. As I mentioned before we went live here, the last times I was on the end of a telephone line with lawyers on the other end, I was being cross-examined admirably or poorly or somewhere in between.
Oh, that's super. Yeah, I mean, we were reminiscing. It seems like a different time. I guess pre-IRPA, when cross-examination, you're saying there was no leave. It was just a lot more of the norm that lawyers would interact directly with visa officers.
Well, I started in 1991, and I think about the time I started, again, it was pre-IRPA. And at that time, lawyers and consultants were at an arm's length, in an arm's length relationship. We had an ADM who decided that lawyers and consultants would be our stakeholders for a short period of time. And that was a very interesting time in the field, because we would have lawyers and consultants come out to our offices and oftentimes sit in our offices with us. We would open their files between us and discuss some of the salient details. We then turned back to the arm's length relationship, and the adversarial nature of immigration law returned. And when I say adversarial, I don't mean that necessarily in a pejorative or in a bad way. It just, keeps everybody within their lanes. So those first three pre-IRPA posts that I had were Korea, Hong Kong, and Singapore. And those were extremely litigious posts in extremely litigious times. Mm-hmm. And because the leave provision didn't apply at those times, cross-examinations were not uncommon.
To what extent?
It's a pretty excellent place to start, though. I'm curious about your thoughts about the more adversarial perspective versus a non-adversarial perspective. Just your thoughts on that different way of managing cases. Do you have a perspective on the pros and cons, kind of from your dealings?
Well, let me finish up on the cross-examination side of things. As I mentioned, just before we went to record, just before we went on the record, as it were, as though this were a cross-examination, the adversarial nature of the relationship didn't have to be a bad thing. It kept both visa officers and lawyers and consultants more or less in their lanes. Unfortunately, pre-leave provision, a lot of lawyers and consultants would add 60 minutes, for example, of cross-examination time in any application. So if a case went to judicial review, there was a throw-in of a cross-examination as well. And in some cases, those cross-examinations were done in all seriousness. In other cases, they were just a throwaway, where they would ask questions to fill up 60 minutes, like where I went to high school, for example, or what the difference between a first secretary, second secretary, and a third secretary were in a High Commission of Canada. So you had all nature of cross-examinations being done, sometimes trying to win the case by finding the weakness, to find the visa officer's error, or to trip him or her up into, admitting to something that was pejorative. And in other cases, it was an honest to goodness attempt to find the flaw in the case.
Very different era now, for sure. I've
sure.
probably done a handful of cross-examinations in judicial review, and never of a visa officer, either of an inspector in a Service Canada audit or of a director who wrote program delivery updates. Like that notion, back when I first started and was able to contact you, we would get lists of who all the immigration program managers were and their emails. Now that's almost never provided. And even when you ATIP it, 3/4 of it will be redacted as to even who the person is. Do you think the current system where there's just no communication is better? Does it harken back to the old days, more preferred?
I'm a firm believer in fairness and transparency, and I didn't like visa officers signing off any letter with correspondence that said just visa officer, no name given. I'm a firm believer, if you're paid to make a decision, you stand by the decision, and you can use your name and say who you are. And as the program manager, you become the lightning rod sometimes for the decisions made by your office. And I'm okay with that too. Not everybody is. I think, post 9/11 and security consciousness changed things a little bit, but I don't think that we had to go that far in being completely anonymous at embassies and consulates and high commissions around the world.
How many emails would you get in a day from random lawyers and consultants?
Lots. In my last post, I was responsible for 12 countries, so you can imagine the volume of incoming emails. A lot of them were redirected if they were case specific. They just were looking for updates in things, and there's a way to go about that to make sure that they go into the right mailbox. But if there's something that's particularly pointy or specific or required the view of a manager, then I would be happy to have a look at it.
Oh, interesting. So we do have an actual discussion and list of topics that we wanted to cover today. The first one though is pretty broad, and it's just given your experience over decades, what programs do you think have worked and aren't working? And this is a bit timely given that the levels plan is going to be released in a few weeks.
Well, it's funny because in public policy in immigration, as well as public policy probably in other departments, what's old is new again. We tend to recycle a variant of particular policies and programs over time. But I would like to harken back to the way things were when I went abroad initially. Our programs were much simpler. They were much simpler for visa officers to select with, but they were also much easier for lawyers and consultants and applicants themselves to apply directly without requiring, a master's degree in immigration law. So I joined immigration almost by accident. I had finished a graduate program in business, and I saw myself as being a better fit to be in trade or in the sort of political stream. And when I was in immigration, I had a look to see what it was that was going on. And I realized that whoever had selected me to join the immigration stream had actually chosen something that was actually a good fit for me. And when I saw what immigration did, that a large part of it was, it sounds perhaps a bit trite, but nation building, and the skilled worker, the independent and assisted relative categories of immigration were front and center for what we were doing. So abroad, we were looking for people who were going to become desirable future citizens, economic contributors to Canada. And it was, frankly, exciting to be part of that.
Interesting. What like how did the programs work back then? Like you say, simpler. There's no big 1,500 point ranking system targeting random little niche, a point system within a point system within a point system.
Exactly.
No, we had a list that was referred to as the demand list, and these were occupations that were nominally in demand in Canada. It predated the intellectual or human capital model of immigration. So we were looking for people with skills in particular occupations. And even in the early 90s, some of the tools that we were using were a little bit antiquated, a little bit quaint, you might say. So the dictionary of occupations that we used at the time was referred to as the CCDO. And I'm thinking back, I even remember the codes 4110 and 4111 for secretary and executive secretary. And in the quaint description of duties performed were things like stenography and dictation.
Were you
I don't think
with
we've come a
applicants
long
back
way.
then? Like, were you interviewing? Were most applicants interviewed back then?
A high percentage of applicants were interviewed. Yes, it's labor intensive, but the outcomes are significantly better, in my opinion. You had a much better opportunity to use positive or negative substituted evaluation or its predecessor. You also had a chance to answer clients' questions, which was a bonus for them. And you also, in some cases, had an opportunity to do counseling. And in many cases, the counseling was more perhaps suitable for people who were being interviewed and selected in the entrepreneur category rather than the skilled worker category, because one would expect that a skilled worker would be able to speak English and or French and have done his or her research into the labor market in Canada. So if somebody was applying in the category of civil engineer, for example, which was on the demand list, that they would have an idea of what was going to be required of them in Canada. Not always the case. So, for instance, in Singapore, we had a broad catchment through South and Southeast Asia, and we had civil engineers in as late as 2002 when I left who hadn't used a personal computer before.
Yeah, what you're talking about, like several of the comments you've made already, are kind of like the depersonalizing of the immigration experience. And, you can see even from early in your career, the way that trajectory began. And I think we're kind of in the penultimate phases.
There are cases in certain environments where you can approve people, you can consider people, and you can consider people fairly and comprehensively on paper. But in other times, you can get more information at an interview than you could ever get on paper. And that's especially true when you're looking at, say, a family class case. When you're having a conversation with somebody who has been sponsored to Canada, you get a much better sense of their relationship in having them explain it rather than provide a stack of phone cards or 100 or 1,000 pages, yes, 1,000 pages of printouts of text messages with emojis and all the cutesy little sayings. That pales in value to what you can get at a short interview.
Well, that's like great. Like, you can get a sense of someone within a minute of meeting them. Sometimes within like 5 words, more than certainly. Well, especially like, so we're going to get to, you used to do a lot of rehab applications. Trying to tell if someone is remorseful from a piece of paper versus in person must just be night and day.
It is, but latterly, we rarely would see an applicant even in a rehab application. But going back, let's finish up with things that worked in the old days. I hear sirens behind you, but that's Vancouver, so it's pretty much nonstop. So, we had skilled workers, and it was really, to me, it was exciting to be part of that because we were getting people who were going to be able to hit the ground running in the skilled worker or assisted relative category in occupations that theoretically had, a demand in Canada. And unfortunately, the demand list itself was not as as plastic or as frequently updated as it could or should have been. But ultimately, that is really what I think that we should be selecting for in Canada, rather than just broad brushstroke intellectual capital. If it's particular occupations in Canada that are in need, then they should perhaps be on the list.
Yeah, I'm interested in the assisted relatives category as well, because I feel like the separation of family reunification from economic factors, I think, is kind of unfortunate, because I think that for me, like, somebody will have all these intellectual skills and that sort of thing, but having family really, I can imagine, has a direct impact on their positive outcomes once they actually come to Canada.
I don't even know what that category is, so maybe you can explain the category.
It was referred to as the assisted relative category. It was kind of a subcategory of the ND2, independent, and ironically, it actually had a negative correlation with successful outcomes, in part because the bonus points one received for having family in Canada was enough to make up for shortfalls in experience, or more importantly, made up for shortfalls in English and or French. So they would arrive, and yes, they had a brother or a sister in Canada, perhaps, but their English or French was subpar, and that's where I think the greatest correlation in success in labor market entry, and just how well are you doing in Canada, is directly correlated to how well you speak one of the national languages.
Mm-hmm. What like in the build up, in the lead up to the levels plan, like, what do you think isn't working now that the government needs to address?
On the complexity, in part, and pooling people in I think that there has to be a mechanism to control whose applications are accepted, whose applications get seen, but putting people into large pools and then just having them waiting around like spawning salmon. Some will get up the fish ladder, some won't. There's a good BC analogy.
I love that analogy. I have not heard that, but that's an image I'm not going to be able to get out of my head.
Yeah.
So those are the things that, truly worked in the old days. One of the topics that we also came up with, you and I, earlier was, what worked with study permits and what worked with work permits. I think the key factor that underscored both of those was temporary. They were temporary programs, and we looked at every applicant who applied for a study permit or a work permit. Can they meet the same criteria that they had to meet, more or less, for as getting a TRV at the time? Are you temporary? Are you going to return to your home country or depart Canada to abide by the Act and regulations once your period of study or your work in Canada is finished? There is no explicit or implicit pathway to permanent resident at the time. So because of that, you got an entirely different type of applicant. And their purpose for coming to Canada was not for permanent residency. There was no dual intent at the time. That said, if somebody's coming to Canada and they're going to spend 3 to 5 years in Canada doing graduate studies in Canada, and they're coming to Canada in their mid to late 20s, the likelihood of them meeting a Canadian and becoming a family class applicant was there. But the likelihood of them applying for refugee status, part of our screening and even the disincentives to apply were such that we didn't see those people making that in large numbers and significant numbers transition from study or work permit to the refugee claimant queue.
Where do you think that starts to fall apart? Is it the programs? Is it schools deciding that they can, international students can be a source of revenue? Is it the provinces for licensing every school that applies?
Yes.
Yeah, that sounds about right.
Yes to all of those. So the study program used to be, I'm thinking about being in South and Southeast Asia. The students who were applying these were serious people. They were serious students. They had the money, or came up with enough money to show that they could come to Canada and, without relying on public resources, go to either do an undergraduate degree and come home with that degree, or a graduate degree again, and bring that skill set back to wherever they came from. Back then, having a credential from a Canadian university or college even would stand you in fantastic stead in your home country, and would provide you with career options that were otherwise either closed to you, provide you with a trajectory up the career ladder much more quickly than you would ever have been able to achieve if you had gone to school locally. Once we went to the current model, where the provinces were approving DLIs to schools, and I use that term loosely, schools in shopping malls and places across Greater Toronto, to a lesser extent, but in Surrey, Greater Vancouver, the provinces had signed off on all of these quote unquote career colleges. That was just about revenue, and it was about the dual intent, although I don't think there was much dual intent there. There was only one intent. And I think we're starting to see that now, as schools, including some legitimate schools, who allowed themselves to be hooked on the income, the revenue from foreign students, having to close down entire campuses, close down programs, for example. And we're going to end up with the numbers are large. I don't know what they are at the moment, but the numbers of students whose intent was not to go home, looking for ways to stay in Canada, either to go to ground, to go underground, or to make a refugee claim. And of course, we know how many years you can drag out a refugee claim if it's initially declined.
Yeah. The government has tried to say that they never dangled the prospect of permanent residence to prospective students. Stakeholders have said that's gaslighting. Where would you fall? Like, you were within the department. What was was the government always clear that there was no preference to international students as work and then PR?
That's disingenuous at best. The amount of gaslighting and prevarication that goes on in that sphere is the stuff you could write textbooks in psychology about.
Yeah.
Mm-hmm. No, I appreciate your candor with that. I think that people feel very duped. And I think it's led to a very high level of frustration and people just feeling kind of abandoned. And
I have no idea what they'll do about it, because it kind of raises like this dilemma of if Canada decides they no longer want these people to immigrate, what do they owe them? It's similar with BC Bill C-12, right? Like, if the government decides that they no longer believe this application stream is valuable, to what extent, are they right to just say cancel it? This is all rumors, by the way, that they may or may not cancel, but they're giving themselves the ability.
Well, even pre C-12, the ability was there. I mean, it's not, the government has canceled large blocks of applications in the past. And of course, that leads us straight into litigation, class action lawsuits, multiple mandamus applications. But at the same time, the other option, where we've also taken the easy path, which is through public policy, and just approved thousands, tens of thousands, hundreds of thousands of study permits, work permits, and TRVs without any real scrutiny, any consideration of program integrity.
Not only that, they explicitly prohibited it from being considered in the 2023 program policy that I think only became public because it was leaked to the Globe. And for those who don't know what I'm talking about, there was a public policy in 2023 that for visitor visa applications submitted before 2021, so essentially had been in the backlog for about 2 years, to just bulk approve them. And then the government had the gall to say, oh, there's a higher percentage than normal that are declaring asylum. Anyway, but so I guess the logic would be, and no one's really talked about when it comes to Bill C-12, like people keep focusing on categories. They also could just say, you know what, your application's been in the queue for a year, 2 years, canceled.
Yeah, and what we're getting from the Prime Minister is there are going to be some hard decisions to make. There is going to be some people who are disappointed and all of this. So I think C-12, as you said, Greg, it's not that these powers didn't exist in various ways. And even our recording with Lauren was like, it's not that these powers didn't exist. It was just they had to be used in a certain way. It feels
they
like
had to pass a law. They had to go through Parliament and pass a law to cancel before. I don't know what it will be now. All they've said is that they're not going to cancel applications unilaterally. So I don't know if that means they're going to go out to some guy and be like, can we cancel your application? No? Okay, well, never mind.
Yeah, I will bring up a legal term that you maybe haven't heard used since law school. And even if it's not the actual legal precept that applies, the concept of promissory estoppel is the thing here. I think they teach you in, not being a lawyer, but I think they teach you in law school that you can't basically lead somebody down the garden path and then slam the gate on them, halfway down, because you've led them on. And this takes us back to, the implied pathway to permanent residence for students or workers. And in any other circumstance, when you've taken people's money, you've led them on that there was going to be a process, and then all of a sudden you have to cancel it. It's much better to fix the program in advance, make decisions correctly in advance to maintain more than a modicum of quality assurance and program integrity, so that you don't have to slam the gate on somebody somewhere down the line.
Yeah. What would you do now if you were the government? Would you say, okay, we're going to, we may have made what we consider to be a mistake in how big it got, but we're going to let these people stay and just make it tighter going forward? Or do you try to, either through canceling or what they're doing, just being super restrictive, nudge people out?
Nudge. I don't think that Canadians have any taste whatsoever for what's going on in the United States in removing people. That said, expecting people to, quote unquote, voluntarily depart, as was the condition that they were given access to entry into Canada, when there is the possibility or the probability of being granted permanent residence, the bill of goods may have come from their licensed or non-licensed immigration consultants in some other corner of the world where, misinformation and disinformation is the order of the day. Doesn't matter. You find yourself in Canada, and whether you're going to trade on the advice of your unregistered consultant has given you in rural India or not, you're not going to necessarily leave voluntarily.
Yeah. So you don't see Canada doing, I don't know what the equivalent of alligators, polar bears, something in Churchill where polar bears are guarding immigration detention centers, similar to alligator Alcatraz?
No, and I just don't think that that's a very Canadian thing to do. But how are we going to do it? I don't know, because I have spoken at some length to the former immigration critic who asked me specifically about amnesty. And I said, while it's the easy way out, it's so patently unfair for anybody who's ever waited in line for anything in their life. And that includes a Rolling Stones concert ticket, or I guess nobody really lines up for a Vancouver Canucks ticket anymore. But
but the Whitecaps are all the rage.
Yeah.
Why don't we actually then switch gears completely to Is it safe to say that you assessed some of the more difficult applications that the department received, rehab, TRP, ARC?
Yeah, you had asked previously who in an office was responsible for considering those applications. And, as long as somebody has the delegated authority, they can consider the application. However, not all managers either have the time or think that they have the time to see ARCs, TRPs, and rehabs. So they often will, allow anybody in the office with the delegated authority, quite often the deputy program manager in an office that's big enough to have such a position, look at those applications. In my last posting, I chose to process enough TRV applications from all of the countries in my area of responsibility just so that I knew what my officers were looking at. And if their TR refusal rates from officer to officer varied for a particular country, I would look at my own refusal rate for those countries and use that as a mean or a median, perhaps, so that I was able to speak to them to bring the refusal rates more or less into a very narrow band, because I think that's only fair to the clients from those countries, that we're not having an officer either be much harder or much softer on those applications. The volumes of TRPs, ARCs, and rehabs were relatively small, but in my last assignment, I did them all myself, partly because, I wanted to see what kind of applications in those categories were also coming through my office, and it wasn't onerous to do all of them. That said, each individual case typically for ARC rehab tends to be
TRP.
complicated and messy, and in some cases rather unpalatable. So, for example, in the case of consideration for somebody in my area of responsibility in a family class case, the applicant had been charged and convicted and jailed for rape. And that is not something that anybody wants to have a look at. Nobody really wants to consider it. But again, as a paid decision maker, that's what you're trained and paid to do. So get on with it.
Mm-hmm. We got a specific question about whether we were asked to do an episode about ARCs and what officers are looking for in an ARC. And I said, great, we're going to have someone on who assessed ARC applications. This will be much easier than Deanna and I trying to guess. So what is it that officers or program managers are looking for when assessing an application for authorization to return to Canada?
Okay, keep in mind that I'm retired 3 years now, and some of this has faded into memory. But the severity of the reason for needing an ARC, of course, is going to be a consideration. I think that all visa officers to a person, try to be fair and are generally common sense about the way they look at things. A serious basis for having been removed from Canada, will play into the decision making. Again, in my last assignment, I had an application for an ARC for somebody who had been in Canada for 7 years and had made a refugee claim, but after 7 years, the claim had still not actually been heard, and it was lost in the administration of the system somewhere. So this particular person withdrew the application for refugee claim and went home and submitted an application for H&C in its stead, which is a logical, practical, and rational thing, as long as that H&C application was going to be heard in the next months or even a year or two rather than 50 years out.
Just for example.
So because the application was well documented, that person's basis for needing an ARC was very clear both in GCMS and in the supporting documents. And as an object lesson to my staff, a short interview was done, and the simple and easy decision is simply to refuse an ARC. Here's somebody who is a former refugee claimant who has another type of application ongoing in Canada. Why would we issue an ARC? But in this case, especially after a 20-minute telephone interview, the ARC was issued.
Interesting. Are there certain
those ARCs are particularly complicated where there is a failed refugee claim, especially when there's a subsequent spousal application where the person has left and, complied with removal, but they met their spouse while here. It feels like it's very challenging to figure out what is the test to meet when you're making that ARC application. So those are the really challenging discretionary decisions I can imagine to grapple with.
I'm also a firm believer in follow-up on decisions that you've made that may be determinative in the future. So a year later, I did follow up on that particular application. And even though at the time I issued the ARC, the person had met a person in Canada and there was a serious relationship, there was no spousal application at the time that the ARC was issued. And subsequently, and in compliance completely with the Act and regulations, a in Canada spousal application either was made or would have been made if the agency hadn't been, but there was no attempt to go around anything. Everything was on the table. The person was absolutely straightforward.
For sure.
Yeah. What about and this before we get to some there's a question we discussed as one that comes up is with rehab. So someone has a criminal conviction, you're assessing likelihood of doing it again. Big factor in that is remorse. A lot of people will say, I didn't do it. I just pled because I didn't have the money to go to trial. Like how that type of stuff that comes up, like how do you grapple with really difficult scenarios like that?
I think that you used the word disgust, DISCUSSED, rather than DISGUST in this case.
Yeah.
Both may apply, but the other term that you used was grapple. And those cases, quite often, you open them up, you look at them, you grapple with them. Sometimes you discuss them with somebody else on your immigration team because you need to hash out both the legal aspect of what you're doing, but also the moral, ethical quandaries that the applications can leave you with. I mean, it's not in any way fettering your discretion or your decision making, but you really need to look at the issue from every side. And there are lots of things that you look at and you find that you are disgusted by what has gone on. And then you have to grapple with and figure out the correct avenue forward that is fair, but ultimately keeping in mind that, the reason we have admissibility concerns is to protect Canada and Canadians.
Yeah. This like, again, I mean, I'm fairly, it's well-trodden ground for me, but I think that when we talk about this sort of thing and this exercise of discretion, it is to me a uniquely human determination. These are ethical, moral quandaries. And, as we said from the beginning, the idea of actually being face-to-face with the applicant seems so fundamental to that kind of a determination. And so, again, I'm going to kind of go back to that, like, do you think that these types of decisions can be ethically and properly made without that kind of face-to-face contact. And, I don't know. I guess I'll leave it at that.
Yes, but it's better, I think, if you have the person in front of you. I'm also a firm believer in telling the person in front of you at the end of an interview, what, if you can make the decision right then and there, what your decision has been, whether that be a temporary resident, a student, a family class case that you're about to refuse on bona fides, or a TRP or a rehab case if the person is right in front of you. I've considered and I've weighed all of the circumstances of your case. However, I don't find them compelling, and your application is refused.
Yeah. Well, this is something that I raised before, like the kind of human touch element and being able to like face your decision maker, and that sort of like accountability is something that we've talked about a fair bit. Like I'm sure that as you face one case after the other, you do have to struggle with your own bias at some times. If you see a case that feels particularly challenging or offensive to you, you do have to struggle with that. But keeping that humanity as a decision maker and being able to say with civility to the applicant, this is the decision I've made and this is why, it feels to me that should be fundamental to the decision-making process. I don't know if you feel the same way about that.
I do.
Yeah.
I feel exactly that way, Deanna. I think you can make better decisions with the person in front of you when it's this type of case where you have to grapple with more than just, is this application complete? Are the documents on file legitimate and non-fraudulent? When you've got somebody who's trying to explain, it's similar to a family class case. If you've got a spousal sponsorship case and you have, one party in front of you, and you can ask a lot of questions and you can find out so much more so quickly and make it a proper, informed decision. And the other one is that sometimes you have the sponsor who has come to join the applicant in the country of interview. And, the question is, well, you have the sponsor available to speak with. Do you want to speak with the sponsor too? And not all visa officers are on the same page on this. However, I'm of the mind that, hey, the sponsor, rightly or wrongly, has traveled all this way. So if there's something still that can be answered only by the sponsor, for example, go ahead and do an interview with the sponsor as well.
Yeah. Well, using another term that has many meanings, some would, say the officer's gone fishing. It can mean hot air. It's a bulk processing software, Chinook. Were you involved? Like Chinook would have been rolling out right before you retired.
I won't. Again, as a program manager, some of those things, I know that my staff were using them to bundle things, to consider things. But again, if I'm processing the occasional TRV just so that I know what my staff are dealing with, I'm dealing with ARCs, TRPs, and rehabs. I'm not a Chinook expert, and I don't consider myself, as I told you before we started here, I'm not a tech guy.
Yeah. But so in terms of discretion, because one of the things that Chinook seems to be designed is to reduce sort of the discretion in how decisions are actually written. And we had Christian Lane, who was a retired CBSA chief, on a couple weeks ago, and he was talking about how in CBSA officers had less and less discretion because the department was worried about the minister being embarrassed. One thing that I've asked quite a few people, and no one seems to agree with me, is whether when it comes to misrep, officers right now, it's either there's no misrep or it's an automatic 5-year bar. To what extent do you think officers should have discretion to impose 0 years, 1 year, 2 year, life, 5 years, or other areas just of where officers need more discretion?
It is a bit of a black and white issue in how long the bar is going to be, 0 or 5 years. But I think the officers have and must have a great degree of discretion in applying it or choosing not to apply it. Again, common sense ought to be the order of the day. You're not there to play God. You're not there to make decisions out of spite. So is the misrepresentation, is it germane? Is it material? Or is it just, administrative slop, for example?
What about did you come across, I think the big one now is the not disclosing a US visa refusal seems to be the bread and butter of misrepresentation decisions.
Mm-hmm.
Yeah, and it's a tough call whether it was a willful omission or not. And, is it something that we would know about automatically as having been informed through our processing systems? Sometimes it's like squishing a fly with a hammer. You're going to refuse the case anyway.
An analogy we've used many times.
And no other visa officer anywhere in the realm would issue the visa anywhere. So adding the, 5-year ban, all it's going to do is maybe save the person, the application fees.
Yeah, right. Like that.
Because the outcome would be the same anyway.
Yeah. I think I've seen ATIPs that kind of speak to that, where if you're going to refuse, you might as well just, it prevents future applications to add the 5-year bar.
It does ask, though, whether or not is it actually a lifetime bar and does it matter once the exclusion period is ended?
Well, that's one thing that tends to, of course, influence anybody. If 3 people before you have refused the same application, or if the person before you has, applied, A40, and now the exclusion period is over and it comes to you, how do you overcome the bias and issue a visa when your colleagues have, chosen not to? Again, one might say that it's walking along a very, very narrow edge. But I do recall having issued, again in my last post, a temporary resident visa to somebody who had been refused at least half a dozen times before. And this is, again, one that you follow up on to make sure that you made the right call.
That's interesting. Do you think, I've never had occurred to me that officers follow up on their decisions, just because I assume a DOJ lawyer once told me that an officer's life is like from I Love Lucy, where they've got to wrap every chocolate going down the conveyor belt, and they're just so far behind that. Was that common that a lot of officers would try to follow up, adjust their decision making?
I mean, if you don't have a feedback loop in your decision making processes, you're really not doing a very effective job. You have no idea whether you're making the right call or not. There's some non or involuntary feedback in this. So if you've issued a TRV and every month you get from CBSA a list of all of the TRVs who have made refugee claims, either at POE or inland, you would then pull that file as a manager. You pull that file automatically and have a look at it. Was it your decision that you made or one of your staff? And would the same decision be made again today if the person were applying? And in many cases, the feedback loop doesn't really inform the decision making, because you look at that application, 6 months post facto, and you go, if that application were in front of me today, I'd issue a visa again, because all of the general conditions have been met. So how or why did that person 6 months on decide to make a refugee claim? Well, clearly, in the case of, say, parents, they've gone and they've spent 4, 5, or 6 months with the child in Canada, the grandchildren, decided that they didn't want to go home to whichever country they were from. And the kids said, yeah, Mom, just go down to the office and they'll take you down there and you can make a refugee claim, and that will allow you to stay here more or less in perpetuity. It saves me having to do with an FC4 sponsorship application. It stops you from having to apply for a super visa for parents and grandparents.
Although if you can tag a 50-year maintained status onto an HNC.
As if you could get 50 years of implied status or maintained status. But I mean, part of my
say that
my
they're going to
question.
try to attach visitor record applications to the online HNC just to have it sit. Anyway, we'll see what happens.
I would be very surprised if that happened, but I would be very hopeful. Yeah.
So going back to your original question, Deanna, I don't know that everybody does it. I don't know how often everybody does it, but
yeah.
Following up on your decisions, irrespective of what category of decisions you're making, it informs your decision making. It makes you a better decision.
Sure. Yeah, no, I totally agree with that. And I'm just curious if, as part of your feedback loop, you issue a visitor visa, somebody comes, makes a refugee claim, and is successful. Is that considered like as the decision maker, would you say, well, that was a negative, like I should not have issued that TRV, or I facilitated?
No, not necessarily, because you have no idea of the things that were not disclosed at the TRV application stage, but you also have no idea who and why somebody on the board has approved the application.
Yeah.
And we would require a hell of a lot more than an hour together to talk about the vicissitudes of decisions made by the board.
Yeah. Well, I think that there is that tension there, though, that the system does put people at the disadvantage of needing to have a TRV in order to be able to make what is whether it's a genuine or a non-genuine refugee claim. So, it's especially now that there's really no opportunity to make an overseas claim. It's sort of, I think people are between a rock and a hard place, I think, is the challenge.
Yeah. No, if somebody has made a claim, and again, we would be advised of this by CBSA, or we found out later on that the person made a claim and the claim was approved, we could look at the original application for a temporary resident visa and go, no, if that same application, irrespective of the outcome somewhere down the line, being what it is, we would issue a visa to that same applicant.
Yeah. Yeah, it's very challenging, though, because it does put you kind of at like, even internally, had you known that they were intending to make a refugee claim, then it would have militated in favor of refusing that application, even though it was meritorious in the end of the day. So it's a bit of a conundrum when you try and walk through it from a level.
Are you able to track like someone's entries and exits? So I did a TRV application for someone from Iraq whose purpose of visit was to attend a concert in Canada, and it was refused. We JR'd, were successful at the JR. The visa was issued on redetermination, and this person and their daughter, went to the concert and went back to Iraq. And I was wondering, I wonder if the officer would see, okay, as implies as big a trip that seemed for one concert. And I'll admit, I was like, okay, that's a big trip for a concert, but I'll believe you. They did go back. Is there an officer? Does that make it can an officer see that someone, hey, this person did come and leave?
But how could they have gone to the concert that they said they were going to go to? Because I'm assuming that
it was the next year. So the concert, it was this annual thing in the city. Wasn't even a big name. It was curious to me that this was such a draw for them, but yeah.
Well, I think that, again, you talk about biases. I think that if the person was applying to go to a Katy Perry concert or any form of jazz concert, I think that would be grounds for inadmissibility. I
still have to make the same joke. Okay. That's right? Awesome. That's funny. And just looking at the time we have left, I have a meeting at 11:30.
As do I.
Birthright, there's some, which one? There's so many topics that come to mind.
I see what you did here. You dragged things out so that we didn't get through our list of things that we
got them. What are we?
So you're going to force me to come back again.
Well, yeah, we're definitely going to force you to come back. we could get we'll add guests after, just in case the person doesn't want their name mentioned. But you know what I've actually like, so again, we're recording this right before. What are you concerned about? Like, having retired and now seeing it, what are you concerned about in terms of where immigration or the department is going?
Good question, Steve.
I wouldn't have agreed to come on this podcast if I didn't care. Retirement is 3 years in the rearview mirror, and I still give a damn. Otherwise, I wouldn't do this. I see the concerns are a loss of quality assurance and program integrity, so that we've issued work permits and study permits and visitor visas to people who ought not to have been granted those status documents. I think that our targets are out of line with our capacity to take up housing, healthcare, and pretty much everything else across the board. I think that we've lost the plot on the work permit file, that we're allowing the work permits and anything requiring an LMIA. I think that we have just basically ignored wholesale the concerns that we have. And these, LMIA fraud is not new. In my posting that I had in Southeast Asia between 2007 and 2011, even at that time, we had uncovered a large immigration fraud predicated exclusively on LMIA fraud. And one of the clients who was part of this actually brought me his money transfers and his contract to a non-official consultant for, at the time, $25,000 to have paid for an LMIA in Canada that didn't exist. And his explanation to me was, yes, I knew that I was doing wrong. And even though I didn't need the additional LMIA points to qualify for permanent residence in Canada, it moved my application to the front of the queue, and the 18 months of reduced processing time was worth the $25,000 to me. So program integrity, the stuff around the LMIA stuff is stuff that I care about. Overall targets, as I mentioned, that are rather ludicrous when you look at the challenges in healthcare and labor market issues and housing. It just doesn't make sense. It's no secret that the government is perhaps in the thrall of the Century Initiative people. That's not conspiracy theory. That's if you look at who the principals of the Century Initiative are and how tied to the current government they are. So,
oh yeah, we did a whole episode on Mark Carney, will it lead to 100 million Canadians? I think it'd be very different if Carney had a majority than how it's being governed right now.
And I have grave concerns about the current immigration minister and her ability to get her head around the issues. And I would say that same concern would be there for the Minister of Public Safety. IRCC,
he's not recusing himself.
IRCC and CBSA work very closely together in, deciding who's eligible, who's admissible, who can come to Canada. Once they're here, how do we ensure that they abide? How do we ensure that they leave as required? I shouldn't probably use the words I want to use to describe both of those ministers, but I would say that they are both extremely unlucky at thinking.
I think that, like, across the political spectrum, I would say there's not a lot of agreement as to what should be, but I think that there is like general consensus that what we have right now is not functioning.
I think that our current immigration shadow minister, immigration critic, I think that she has a very good idea of what we need and what we don't need. I don't know that she has a great sense of, again, how are we going to get the tens of thousands, hundreds of thousands perhaps millions of those who came here nominally, temporarily to depart.
Yeah, are you worried about like you said at the beginning of our recording that you don't think that what's happening in the US is very Canadian. I don't know. I think that what keeps me up at night is like I don't know what the Canadian solution looks like. I can't envision it, you know.
I agree with you. I'm on the same page as you, and I talked with my CBSA former colleagues, and they don't have a sense of it either, an answer for it. Whatever it is it's going to be, it will be ugly, and it will be very, very expensive, and it will probably be if we fix the front end problems, it'll probably be a decade to fix the back end problems.
But wait times are a Canadian way of doing things, not just.
Well, you know, I think that this is just it. Like what in Steve's discussion with Christian, he was talking about like what causes people to go into the public service, to enter this line of work. And it's like a real commitment to try and achieve realizable goals. And I think that we end up setting ourselves up in this adversarial relationship where we want this and you want that and all of this sort of thing. But I think that right now, I think one thing that everybody seems to have in common is that we don't want that. We definitely don't want that. And so, you know, I think we're really just struggling to kind of figure out, like, how do we come to something that feels more rational and doesn't look like that?
But fairness matters. You came
for sure,
and irrespective of whether you were sold a bill of goods by a non-registered consultant or registered consultant in your country of origin, or there was something more specific on the dual intent or implied or explicit pathway, you're here temporarily. Temporarily means exactly that.
No, lots to think about. We'll have to definitely have you back on. We've met in person, but also next time you're in Vancouver, let us know, and like the three of us can grab lunch or something.
Okay, no.
This has been fun.
Yeah, definitely.
It's been nice to have a non-adversarial relationship with two lawyers on the other end of a line, and I'm not being
cross-examined. Right? I sometimes felt like I was falling into that position, and I apologize. But again, emotions are running high. This is such a tricky time.
Well, I was joking with the DOJ lawyer that I was going to relitigate that case that we were involved in with the benefit of him not being there.
Yeah, that's right.
Well, I will give you a quotation from back in the cross-examination days. There was a lawyer and her spouse on the line with me. And just before we went on the record, the lawyer who was going to do the cross-examination, her spouse said to me, "When my wife gets through with you, you will think that your upcoming area trip to Bangladesh is like going to Club Med," unquote.
Oh, boy.
And